Folks, this is an absolutely fascinating book. You can tell by the author, Gary McDowell. He's fascinating, too. And full disclosure, he is a board member at Landmark Legal Foundation, and it's an honor to work with him. And I worked with him at the Justice Department and the Reagan administration. This is really, really an interesting and compelling book. The Language of Law and the Foundations of American Constitutionalism by Gary McDowell. We have it on marklevinshow.com. We have it on my social sites. I cannot encourage you enough to get it. It's often said that really what's foundational about his philosophy is he focuses on human experience. And yet he doesn't focus on human experience to the exclusion of reason. He also talks about or writes about natural law, and yet he believed in God, but natural law wasn't necessarily God-given. How do you square all this? How can you do this in 7 minutes?
Well, I think the way you square it is this. Locke was predominantly a modern thinker, and as a modern thinker, he rejected a lot of the old-fashioned natural law thinking of the medieval days. And he, along with people like Hobbes, were concerned with getting it right and getting a foundation for politics that would not depend upon somebody having to make excursions into the netherworlds of unknown, unwritten law. And his whole notion is that government, to be legitimate, must rest upon the consent of the governed. And the consent of the governed is the reciprocal of equality. Because we're all created equal, we have to consent to the government under which we live. Otherwise, that government will be arbitrary and illegitimate. And that's what made him such a big sell among the founders.
But what's interesting is Burke had a real problem with Locke because he felt he wasn't focused enough on faith and tradition. Is that right?
Well, I think that's right. In one of Locke's more interesting books, in fact, the most important book he wrote, the Essay Concerning Human Understanding, he makes the argument that when you create a government, when you create a society, there's the need to have a God. And it's instructive that he says a God. He doesn't say God, he doesn't say the God, he says a God in a utilitarian sense. So he was not religious in the sense in which a lot of our fundamentalists today would understand him being religious. But he understood the grounds of getting government right, and to get government right meant that it had to be non-arbitrary. It had to be resting upon the consent of those who were going to be governed by it, and that's what made it legitimate and nothing else.
Now, your comments or your writing on Hobbes is very interesting to me. I find Hobbes to be a little complicated. I don't mean his writings per se, but him as a thinker. On the one hand, he messes around with this model of sort of the perfect human society, right? And is that just an exercise that he's involved in?
Well, I mean, there's an argument. I think it's a powerful one and a correct one. Pierre Manon of Paris has made the argument, and others, that Hobbes is really the beginning of liberalism, that's where we get our modern liberalism in its most primitive form from Hobbes. What we get primarily from Hobbes is filtered through Locke, filtered through Blackstone, filtered through a lot of other people who come after him. He was reviled in his own time by many people. He was considered to be a danger. They blamed the Great Fire of London on him, on the publication of Leviathan. I mean, all kinds of things.
Well, let me stop you right. The Leviathan.
Yeah.
Well, that's sort of a totalitarian society.
It's not, well, it's totalitarian in one sense, and that is that the sovereignty, once created by the people, is to be supreme and to be complete. That sovereignty does not necessarily mean in Hobbes to be a single individual or a dictatorial presence. It can be an assembly, as he says. It can be a collection of men. It can be however the people themselves see it as fulfilling their needs. That's what sovereignty is going to be. And so, at one level, he's accused all the time of being the father of arbitrary and totalitarian regimes. I think that's completely false. I think he's the father of modern liberalism in a constitutional sense.
That's interesting. You and I would have a slight disagreement on that, but I do find it. It is said that he's the father of modern liberalism, and yet, on the other hand, I can't get around this Leviathan.
Well, Hobbes has a great paragraph, and it's a paragraph that's picked up and repeated almost verbatim by Locke. And it's something like this, that the laws are not intended to keep people from exercising their free will, but laws are meant to serve the role as hedges, keeping people in the right path so they don't hurt themselves, they don't destroy themselves. And that's a very modern, liberal, constitutional view of what law is all about. It leaves us free to do what we will as long as we don't hurt ourselves or another, really.
Now, you seem to think, or you suggest, that Locke while he may have outwardly repudiated, or worse, Hobbes, that he may have borrowed from him.
Oh, I think he borrowed very heavily from him. In fact, that's what a lot of this book is about, to try to show how Locke is at heart a Hobbesian.
Boy, you're going to get hell for that from some quarters, I can tell you that. I can think of a few, but all right, let's talk about present day now. Here we have a judge in San Francisco who really took the 14th Amendment and rewrote it. Right. I don't care what people's views are on the end product, but he really rewrote it. There is no history to support what he did. There's nothing to support what he did. What do you think Locke and Hobbes would say about that?
Well, I think it's one of those things that you look at a judge like this, and he's a very clear example of what we all argue against, and that is the importation of private notions of justice and veiling them in the raiment of fundamental constitutional rights. And what he's basically done is to reach a conclusion that he thinks is just in his own view and tried to make the opinion support that. I read the opinion pretty quickly this afternoon, and I don't think it's going to be praised as a great piece of jurisprudence in the years ahead. But, I mean, he's guilty of exactly the thing that we've always argued against, and that is a judicial activist. He is undertaken to make the law stretch to meet the ends he wants to reach, and that's what he's done in this particular case.
You know, you being the philosopher that you are, at least studying philosophy, Frederick Bastiat used to talk about how these folks on the left, well, we call them the left today, how they use the law to really impose their views, and when we try to use the law to defend ourselves, then we are attacked for using the law in an honest way. And I just think it's interesting that when organizations say, you know, we need a constitutional amendment on traditional marriage, or we want to discuss this issue, they're creating a wedge. They do this wedge politics, and now this judge has done this, and if you dare to speak out against it, you're for wedge politics.
Right. And there's also lots of ironies related to this case today, this Perry versus Schwarzenegger. And one of the ironies is, of course, it was a question of the referendum and initiative, which was originated by the progressives back to get around the structures of government that they thought were not fulfilling the direct democracy that they wanted to see. And now you have a federal judge coming in and imposing his will to strike down what the people of California wanted to do in their own name, direct democracy, to establish Proposition 8 and to amend the Constitution as they saw fit. Having a federal judge come in and say, no, you may not do that. It's really, really outrageous at a lot of levels.
Well, isn't this kind of tyranny at a lot of levels? I mean, because when the end result isn't what the process delivers, you go follow another way and hope you get to the end result. In other words, there's no winning. There's only losing.
That's right. I mean, Locke had this great line about where the law ends, tyranny begins, and I think that attaches to the whole idea of judicial-made law, constitutional law in this sense, even at the state level. That what we have here is a judge behaving in an arbitrary fashion to reach the ends he wants to see fulfilled as a matter of public policy. And that's not what free government, self-government is all about.
Now, the Founding Fathers, in constitutionalism and so forth, they really were well read. They had read a lot of John Locke, didn't they? And I guess you would argue Hobbes, and really even more than that, didn't they?
Oh, they were widely read, and they read in a very utilitarian way. They were not trying to assemble their libraries for ostentatious purposes. They were assembling their libraries to make themselves statesmen and to use what they read and put it into effect as best they could. And that's what makes it such a wonderfully rich era to look to understand what they read and how they read it and what conclusions they drew and what they were trying to do as a matter of establishing free constitutional government.
Isn't one of the great, unique aspects of Locke, and I think you would argue Hobbes in your case as well, is that their philosophies really were philosophies at understanding the human being, whereas so many before them and so many after really are trying to force the issue and create models, whereas they were really trying to understand how humans think.
No, that's right. They were trying to get to the bottom of what human nature was all about and what you could expect from it and what you couldn't expect from it and why you wanted to have a certain kind of government that would be legitimate and to avoid others that would be inherently illegitimate. And that was all rooted in an appreciation for human nature and what mankind was all like. And, they did a very impressive job of laying that out in a way that could influence generations.